Can an easement be terminated? Have you ever wondered if an easement can be terminated? This is an important question for anyone involved in real estate investing. Understanding easements is crucial because they can impact property value and usage. So, let's break down how easements can be terminated and what that means for you. An easement is a legal right that allows someone to use a portion of another person's land for a specific purpose. This could be for access to a road or utility placement. While easements can benefit some, they can also limit the property owner's control. One of the simplest ways to terminate an easement is through a mutual agreement. If both the property owner and the easement holder agree to end the easement, they can create a written document to do so. This agreement should be signed by both parties and recorded at the local land records office to be legally effective. For real estate investors, this can clear up title issues and make the property more appealing. Another way an easement can be terminated is through abandonment. If the easement holder stops using the easement for a long time and shows no intention to resume, it may be considered abandoned. However, proving abandonment can be tricky. It requires clear evidence that the easement holder intended to abandon it. Easements can also be terminated by prescription. This occurs when the property owner openly interferes with the easement holder's rights for a certain period, usually around 5 years, without the easement holder taking legal action. This method requires careful legal handling to avoid disputes. Some easements have a specific duration or conditions attached. When the expiration date is reached or the condition ends, the easement terminates automatically. It is wise for investors to review easement documents for any such clauses. Easements created out of necessity can end if that necessity no longer exists. For example, if a landlocked parcel gains access through another route, the easement may terminate. If the property owner acquires both the dominant and servient estates, the easement can also terminate. This is because one cannot have an easement over their own land. In cases of disputes or unclear situations, parties can seek a court order to terminate an easement. This may involve quiet title litigation or other legal proceedings. For real estate investors, it is essential to understand how easements affect title insurance. Clear documentation of any termination is necessary to avoid future claims. Property owners should never attempt to terminate easements through hostile actions, as this can lead to legal trouble. Consulting a real estate attorney is always a good idea when considering easement termination to ensure compliance with local laws and proper documentation. In summary, easements can be terminated through mutual agreement, abandonment, prescription, expiration, necessity ending, merger, or court action. Knowing these methods is vital for managing property rights and protecting your investment.